Welcome everybody to webinar number 7, the impact of diversity in court and arbitral decision making. My name is Michelle Lindholm and I'm your moderator. Today we are honored to welcome two expert speakers, Judge Bernice Donald. Judge Donald, I think your video is still off. Oh yes, now we can see you. Welcome, Judge Donald, and Mr. Manfred Wondrak. Judge Donald is a judge at the U.S. Court of Appeal, the Sixth Circuit, since 2011. Before that, she served as a judge for the Bankruptcy Court and the General Sessions Criminal Court. She was the first African-American woman in the history of the United States to serve as a bankruptcy judge, and she was the first African-American woman to serve as a judge in the state of Tennessee. Judge Donald is a well-known public speaker and publishes and lectures on the topic of diversity. Manfred Wondrak is a bias and diversity expert and owner of Factor D Diversity Consulting. He operates the platform antibias.eu and advises about 20% of German and Austrian listed companies and other global players within the DACH region. He is a sought-after keynote speaker, lecturer at several universities, and publisher of the first practice book Diversity Management in Austria. Please, all participants are invited to ask questions during the talks, and I will collect them and ask them at the end of both speeches. May I leave the floor to Mr. Wondrak?
Thank you. Okay, thank you very much to AIJA and Michelle Lindholm. I'm really happy to have the opportunity to talk about the subject of unconscious bias here at the 58th Annual Congress. Ladies and gentlemen, we make a lot of decisions in an average day. Most of the time they're the right ones, but if we are honest with ourselves, we know that not all of them are necessarily the best ones. For instance, we over or underestimate other people's competences. We're influenced by a group or individual people, and we are quick to allocate attributes to certain subgroups. We all like to think that we are open-minded. However, we tend to subconsciously like people who look like us, act like us, and come from similar backgrounds. The main reason behind this is that there are unconscious biases which influence our thinking and decision-making processes. What makes these traps so dangerous is their invisibility. They can even lead us to make decisions and behave in ways which are contrary to our beliefs. In the next 20 minutes, we look firstly at our thinking and decision-making processes and at what unconscious biases actually are. Secondly, I would explain a number of well-documented bias types that could undermine people's decisions. In fact, Wikipedia describes more than 170 different types of biases, so don't worry, I will only discuss the most common ones, so about 5 to 6 bias types. We will review the causes and manifestations of these traps, and finally, I will highlight specific strategies and tools to minimize their effects. I want to start straight away with an example. Here is an exercise in which you can test your perception. On the slide behind me, there are various men. They have just a few distinctive features which are listed below. That's height, their attire, skin color, names, and body type. These 4 men have one thing in common. Each of them has applied for an open position, a board position in a huge corporate group, let's say a company in Europe. And the question I have for you now is, who do you think will get the job on the board? Who statistically has the best chance? So we have prepared a poll, and I've started that, and actually you should see it now on the screen, the question, and then please choose who do you think will get the job on the board. So the first results are coming in, perfect. Good. Super. Wonderful. Okay, so it's stopping. Okay, another. So 2 seconds more. I think we can stop it because we have already clear results. I will stop it now and show you the final results. So yeah, I think Alexander is the winner. And yes, you are right. Statistically, Alexander is more likely to get the job, but what are his competences? And obviously, there are some attributes that gave him an advantage. Research has proven that, for example, attractiveness and height are beneficial for careers of men. The US-American researchers, Judge and Cable, conducted a study. They found that 60% of male CEOs in the US are taller than 1.83 meters. Even though less than 50% of the American population is in that height bracket. In fact, what you experienced is a very efficient thinking process, which we have acquired through evolution. Susan Fiske and Amy Cuddy, two researchers, they proposed the stereotype content model in 2002. This model suggests that all group stereotypes and interpersonal impressions form along two dimensions, warmth and competence. Let's go back 10,000 years when a Neanderthal man spotted a stranger. He had to ask himself two things. Firstly, do I know this person? Do I feel warm towards them? And secondly, are they dangerous? Might they attack and harm me? This corresponds with the competence level. So the real question was fight or flight. Very effective. This process has been proven over thousands of years. However, as we have seen in certain situations, it could lead us to bad decision making. A lot of research has been conducted in the field of cognitive science in the last 10 years. We have two systems of thinking. System one is the fast thinking, the unconscious, and system two is the conscious thinking, the slow thinking. Let me briefly explain the major findings of how our impressions are formed. Firstly, the importance of the unconscious. 100 years ago, my fellow resident of Vienna, Sigmund Freud, he described the unconscious as being a place comprised of thoughts which should be concealed. Today, we know that the unconscious is a very efficient system which enables us to survive and act in a complex world. Actual figures from research are that 90% of decisions are subconscious and only 10% conscious. Daniel Kahneman, a Nobel Prize winner and author of the bestseller Think Fast and Slow, explains in his book that the unconscious uses schemes, that is to say categories, so group stereotypes are categories. On top of this, the unconscious uses heuristics. Heuristics are rules of thumb and mental shortcuts. Thirdly, our mindset forms our expectation. It's like a filter, a lens. We rely on patterns that we learn to recognize over time. And they are made up of our instincts, the culture in which we were socialized, personal experiences, and also the media. Finally, the context is important. It makes a difference whether I meet a tall man at night alone in a dark street or at a party. And what is unconscious bias? We can define it as a skewed information processing under the influence of context, of accumulated experience and emotions. So let us now look at some examples, some bias types. I've prepared a video for you. It's a powerful example of how context can influence. It is called social proof. I will show you a video of the Solomon Asch experiment from the 60s. The video footage is old, but it has been restored.
The Asch experiment is one of psychology's oldest and most popular pieces of research. A volunteer is told that he's taking part in a visual perception test. What he doesn't know is that the other participants are actors, and he's the only person taking part in the real test, which is actually about group conformity.
Please begin. The experiment you will be taking part in today involves the perception of line length. Your task will be simply to look at the line here on the left and indicate which of the three lines on the right is equal to it in length. So, for example, if you...
The actors have been told to match the wrong lines. The volunteer will be monitored to see if he gives the correct answer or if he goes along with the opinion of the group and gives the wrong answer. In the first test, the correct answer is 2.
1. 1. 1. 2.
1. Once again, the correct answer is 2.
3. 3. 3. 3.
3.
The AIJA experiment has been repeated many times, and the results have been supported again and again. We will conform to the group. Again, we're very social creatures. We're very much aware of what the people around us think. We want to be liked. We don't want to be seen to rock the boat, so we will go along with the group. Even if we don't believe what people are saying, we'll still go along.
1. 1. 1.
1. Group dynamics is one of the most powerful forces in human psychology.
1. 1.
Yeah, actually this phenomenon has also influenced our laws. In 2009, also the European laws, in 2009, the International Monetary Fund asked themselves the following: why didn't we foresee the 2008 financial crisis? It was our duty to do so and to warn our member states. They instructed another company to conduct an inquiry. The final report contained two major findings. Firstly, they complained that the decision-making bodies were too homogeneous. They were mainly composed of men, all of whom were well qualified, educated in elite universities in the US. They came from the same economic classes. All had a kind of group thinking. So it was suggested that decision-making bodies should be more heterogeneous in future. And secondly, the inquiry showed that there were some staff members who had forecasted the crash. However, they didn't dare speak up and impose their opinion because they feared a negative impact on their careers. Here we have what we call diversity and inclusion. Diversity of heterogeneous teams with different perspectives, but this is not enough. There is also a need for an atmosphere in which people can bring forward the arguments, in which they can speak up and raise their voice. This is inclusion. Let us take a look at automatic stereotyping by using gender bias and traditional role models. Thinking in categories is another source of biases. Here we have a simple study which has been conducted by Google around the world. The first question was, what comes to mind when you think of a typical manager? Which attributes do you associate with them? And the second question was, which characteristics does a typical man have? And the third question was, which characteristics does a typical woman have? And after that, they checked which attributes overlapped, and here are the results. 71% of the manager's attributes listed overlap with the words which were used to describe men. And only 10% of those words have overlapped with the words usually associated with women. Abstractly speaking, it just means that the qualities we think men have are also naturally the qualities that good leaders have. And this can impact our decisions. Stereotypes have two functions. Firstly, a descriptive function, how are typical men and women, and secondly, a prescriptive function. We also expect that men and women should behave in line with traditional gender roles. If they do not, then it could lead to discrimination and sanctions. And here's a wonderful example. Ladies and gentlemen, let me introduce to you Heidi Roizen. Heidi Roizen is a venture capitalist in Silicon Valley, very successful in a typical male-dominated field. She was part of a case study at Harvard University. Students received Heidi's CV and they were asked two questions. The first was to assess her competencies, and the second was to determine whether they wanted to have her in their team. Then they formed a second group. They also received Heidi's CV. However, the first name was swapped with the male name Howard. And what they found was Howard was rated as super competent, and they wanted to have him in their team. Heidi was rated as super competent, but they didn't want to work with her and they wouldn't hire her. Maybe you're smiling, but this is very common. Women who have made it to the top are often seen as arrogant, cold, uncaring mothers or stubborn. But I have good news and bad news. Good news for the girls, it doesn't apply to women only. And the bad news for the boys, it might also hurt men. It is just the other way around. For example, when a man wants to take parental leave or when he has a soft handshake. Here are 3 more bias types. The first one, similarity bias. So the picture gives you all a clue about what it means. We like people who are like us. Let's assume you meet an applicant or a client who mentions that he or her went to the same school as you did. You feel warm towards this person. There's a warm gut feeling. The person seems trustworthy. This effect can influence people who are younger versus, this can influence careers as well as decisions in court. We tend to mentor people who are a younger version of ourselves. And this tendency also reinforces the status quo in terms of ethnicity, race, gender, and even management styles. The second one, salience error. Remember Alexander. Prominent aspects often receive excessive attention and can thus influence your assessment. This might include an easily visible behavior or a personal feature, but also can include information that we remember easily. For example, if someone is very attractive, overweight, of high stature, has graduated from an elite university, or is a famous person. And the third one, the confirmation bias. This is the tendency to focus on information that confirms initial impressions rather than gathering all relevant evidence. So let me summarize. As I mentioned before, a heuristic is a mental shortcut. It allows people to solve problems and make judgments quickly and efficiently. This rule of thumb strategies shorten decision-making time, and it allows us to function without constantly stopping to think about our next course of action. However, they can often steer us in the wrong direction, such as automatic stereotyping, which is the spontaneous activation of beliefs about a particular group. How women are, how Black people are, how Asians are, or how Austrians are. Similarity is positive. We like people who are like us. Our unconscious also tends to overrate proximity in time and space. It focuses more on short-time gains. Bad is stronger than good. This also applies to losses which loom larger than gains. People are more willing to take risk or behave dishonestly to avoid a loss than to make a gain. The effect is called loss aversion bias. Our fast thinking tends also to opt for more of the same. It heavily relies on our experiences and the status quo, and it could lead us to make decisions actually which are contrary to our beliefs. So what can we do? How can we address our biases? Here are some tips. Analyze your own thinking patterns. For example, when you see people, analyze how you perceive them. What do you focus on? What does that tell you? Do you react positively or negatively? Question your first impressions. Always back your gut feeling up with facts, with evidence, or get multiple other independent opinions. Take breaks. The power of strategic breaks to refresh your brain and to see a situation in a new way is scientifically proven. Make a walk, sleep over a decision, or take a power nap, and then revisit ideas to see them freshly. Look for counterexamples. Think of a person who contradicts a common stereotype. These positive examples could be abstract, maybe a female board chair, famous like Barack Obama, or someone you personally know. Change perspectives, change your viewpoint and thinking patterns by adopting a different role. Put yourself in someone else's shoes, maybe your clients, your customers, or in the role of a stereotyped group, let's say refugees. How would you feel if you were in their situations? What perspective would you have? What decisions would you make in this situation? Well, and finally, the most important thing is that you become aware of your personal biases and start to take countermeasures. Well, in this sense, the time is short. I wish you many bias-free decisions, and thank you for listening.
Thank you, Mr. Wondrak, for this very interesting talk. Now, may I leave the floor to Judge Bernice Donald.
Thank you, Michelle, and thank you, Dr. Wondrak. I'm going to talk about the impact of diversity on court and arbitral decision-making, and I'm going to reinforce or restate some of the things that Dr. Wondrak said, just because I think that through repetition of these things, we become more aware and they enter more into our thinking and processing. So you heard Dr. Wondrak talk about what is implicit bias. And so I'm going to share that with you. Are we sharing the screen yet? Okay. So implicit bias is the attitude or stereotypes that affect our understanding, our actions, and our decisions in an unconscious manner. I think, as he alluded to, these biases are not always unfavorable, but they can be favorable or unfavorable, and they're activated without our awareness or control. If we are a judge and there are attorneys coming into our courtroom all the time with whom we have a good rapport, we're likely to activate our favorability thinking more so than we would somebody who is an unknown to us. We are looking at the familiar, that person perhaps looks like us and acts like us. And so we're favorably disposed to hear their arguments. And sometimes it can affect our outcome. If the person is someone unknown to us, perhaps a member of an out group, perhaps a group with whom we hold negative stereotypes, that too can affect our outcome of that individual. Now, where do we get these stereotypes? As Dr. Wondrak said, they come from all over. They come from our cultural upbringing, they come from our familiarity, our associations, but they also come from folklore and from media. So I want you to look at this particular slide. We know that in the US, at least, and perhaps in Brazil, there are certain stereotypes that are associated with African Americans. And sometimes if we see an act that confirms or activates that stereotype, we can react to that, and we also can absorb it. It confirms our prior thinking. This slide comes from the same newspaper out of New Orleans, and it's a slide from events that happened immediately after Hurricane Katrina. So on the slide that is to my left, you'll see what appears to be an African-American youth. And the headline reads, and these are actual headlines from the newspaper. The headline reads, "A young man walks through chest-deep floodwater after looting a grocery store in New Orleans on Tuesday." Now, over to the right, you see people who are suffering as victims of that same hurricane. They appear to be white. They have what appears to be groceries in the water with them, but that headline reads, "Two residents wade through chest-deep water after finding bread and soda from a local grocery store in New Orleans." I want you to be mindful of the stereotype here. If there is a stereotype that is activated for African Americans and criminality, if that's the association, you see that reflected in the news line. While they're engaged in the same conduct, one has a criminal connotation, looting, but over to the other side, you see the same activity, but there is an association of finding, and there is no criminality associated with finding. So the same activity in the same city, from the same newspaper, from the same natural event, is characterized differently depending on the race of the individuals. And I would submit that that is probably borne about by stereotypes. I'm showing you a media image now, think about those same kinds of incidents in our courts when we're making decisions. If we hold a stereotype or an unconscious belief that certain groups, certain racial or ethnic or even gender groups are associated with certain types of conduct, that could very well influence our outcome when we're making decisions. And that's why, as Dr. Wondrak said, we need to be acutely aware of our own biases and our own thinking, And it's important to do some other things when we enter upon the decision-making process that I'll talk about a little bit later. So as I said before, where do these stereotypes come from? Well, in the US, we know, and in some quarters of Brazil, I mean, in some instances, Brazil also, many of these stereotypes have been around for a long, long time. They go back through time. And many of them were born about through colonizing efforts of countries and colonizing indigenous populations. In the United States, we had a long and brutal history of slavery. There were many stereotypes and actions that came about during that time that are still a part of our culture today. They may not be at the conscious level, although some are, but many of them still are unconscious, are at the unconscious level. Many of the things that we are reacting on today can be traced back to those stereotypes and practices that were developed for population control during those times. There were stereotypes that were activated through the Civil War, and then a long period of state-sanctioned segregation and the Jim Crow laws, which sought to dehumanize certain populations and keep them under control of the state. So what was the objective of those populations? Well, in the US, the primary objectives were to promote an enhanced white superiority and to infuse the culture with notions of Black inferiority. And there was always a goal of dehumanizing. You could not justify some of the brutal treatment for people that you recognized as a human and having the same characteristics and the same rights as the majority race. So there were tremendous dehumanizing efforts. And many of those things still flow through today, and they are embedded in our psyche and unconsciousness. So that's just part of the root cause. There's a lot of impact on skin tone. And I want to mention this to you, because look at your criminal population. Here, there have been a number of studies done on populations and skin color. In the state of Georgia, Professor Tracy Birch from Northwestern University looked at the prison population there. And what she found was, because Georgia kept, and perhaps still do keep their populations not only characterized based on race, but also on skin tones. What she found was, in looking at similarly situated inmate populations, that in the African-American statistics, people who were darker and had more Afrocentric features were sentenced more harshly by the courts than were their light-skinned counterparts. The lighter the skin tone, the closer to the sentencing of white defendants that came. And I want to tell you, that has occurred with not only white judges, but it's also occurred with judges who are people of color. A judge who was a friend of mine in the state of Maryland said that he was written a letter by a defendant, and the defendant accused the judge of being biased because the defendant was white. The judge took that to heart and did a self-audit. What the judge said he found was that he had not sentenced white defendants more harshly. He had in fact sentenced Black defendants more harshly than white defendants. And again, the more Afrocentric the features, it appeared that the harsher the sentence was. So these biases are not reposed in any one racial or ethnic group. As I think Dr. Wondrak mentioned, we all have these biases. Not all of them are negative, but some are. And we as stakeholders in the justice system have to be concerned about negative or unfair outcomes when we're looking at the decisions that we're making. So Dr. Wondrak mentioned that probably 90% of our biases are unconscious, that thought process, and only 10% are at the conscious level. So a lot of our decisions are made in that unconscious realm. And our mind processes enormous amounts of information. And so it has to rely, in many instances, on these things that are embedded within our thought processes that we may not be aware. I want to give you just a couple of examples from US law. The first one is a case that goes back to 1857, a case called Dred Scott versus Sanford. And I'm not going to go into this in great detail, but in this case, the Supreme Court, U.S. Supreme Court said that African Americans were not entitled to be not entitled to citizenship under the U.S. Constitution, that it never envisioned them. And through a lot of legislation and court edicts, African Americans were deemed ultimately under the 3/5 compromise to be 3/5 of a person. So that again gets into the dehumanization part. But I put this slide up here to give you the words that the Chief Justice of the U.S. said in that case. What he said was, and this was Chief Justice Taney, he said that, and he didn't use the term African Americans, but he basically said African Americans, an African American man has no rights that a white man is bound to respect. And so part of that thinking, part of that characterization leads to some of the inferiority that we in the US are still grappling to overcome today. I'm not saying that it originated with Chief Justice Taney by any means, but I am saying that that is furthered in our jurisprudence and in our cultural norms today. If you go forward for a period of time, we got to Plessy versus Ferguson, where in terribly unequal conditions, the Supreme Court has said it's okay. It said that racial segregation is okay as long as there are separate and equal facilities. And so we went through this period where Blacks had to drink from fountains made colored, identified as colored. They could not drink from white water fountains. They could not try on clothing when shopping in stores. Only whites could try on those clothing. They had to sit in separate places in theaters. And there were just a whole bunch of things. In Memphis, where I am, African Americans could only visit the zoo on one day of the week, and whites did not visit the zoo on that day. So all of society was segregated and separated. And this notion of otherness is what part of this bias is based on. Brown versus the Board of Education was a signal case where the court said that separate but equal is inherently unequal. And one of the slides that Dr. Wondrak mentioned before, I just want to sort of pile on. He showed you the slide of the woman. Well, in the United States, there's a great case, Price Waterhouse versus Hopkins, where Miss Ann Hopkins was the victim of sexual stereotyping. She was not promoted because she was exhibiting these characteristics that are normally associated with male leadership. And they were considered negative characteristics when exhibited by a woman. So they said that, her problem was that she needed to act more femininely. She needed to dress more femininely. She needed to wear more makeup and more jewelry. And oftentimes today, when we're looking at women in politics, people will often comment on the woman's clothing rather than focusing on other traditional characteristics that we look at in male leaders. So we need to be mindful of that. I know that in Brazil, there has been a lot of discussion about pay equity. And this results in sort of how we value work and who we believe should occupy certain positions. Oftentimes, if we believe that the work that is traditionally done by women, first of all, that's accorded to a lower pay. If a woman is doing that non-traditional work, oftentimes she is viewed as not providing the same value that a male counterpart would. And so the goal is to work toward pay equity, and I just put a case up there for that. In sentencing, I've already alluded to this, but oftentimes we see drastic differences in sentencing for people of color and people not of color. And so you need to look in your own jurisdiction to see if there are sentencing patterns. And for judges, we need to become self-aware, and we probably need to do our self-auditing. We need to, in the quiet of our chambers, when we're sentencing people who are engaged in similar conduct, look back and start keeping a record of what you do and how you sentence. Let me give you an example from my time as a judge on the court. I was in court one morning, and there was an African-American defendant. He was an African-American male, probably in his late 40s or early 50s. He was before the court on a charge of possessing a weapon while being a felon. there were 8 weapons, and this gentleman pled guilty to this 8-count indictment. And I took his, after satisfying myself that his plea was being made knowingly and voluntarily, I took his plea. That afternoon, there was a young white defendant standing before the court. He was charged in a 2-count indictment. Count 1 was possession of stolen weapons, and in parentheses, there were 8 weapons, but they were all subsumed in 1 count. Count 2 was being a felon in possession of firearms, and there were 8 weapons, all subsumed in 1 count. And I want you to remember that the African-American had an 8-count indictment to which he pled guilty for each and every count. The white individual who had the same number of weapons pled guilty to 1 count because all 8 weapons were subsumed in 1 count. When I ask people, if you're looking at somebody who's got 8 convictions for being a felon in possession of a firearm, and you're looking at a person who has 1, who is the more dangerous in your mind? Who do you think of instantly as the more dangerous? And invariably, people will tell me the one with the 8 counts. Here, they both had the same number of weapons. It is just how the conduct was charged. So if you're a judge, look at how your prosecutors are charging conduct. Does that conduct have a racial disparity? And if it does, what can you do? Well, I'll tell you what I did. I held up the indictment on the young white male, and I called the prosecutor down and I said, look, why are you charging this way? You should not have different charging policies coming out of the same office. And they said to me, well, it's not going to really make a difference because they're all going to merge at the same, at the end, and that you have a standard guideline range that applies. Now that sounds, pretty seductive. It sounds like, okay, maybe that's right. But at the time of that case, a defendant convicted of a felony in federal court, each defendant was required to pay a $100 special assessment. So that means that the African-American was going to have $800 in non-waivable cost, while the white individual was going to have $100 in non-waivable cost, because the government was dismissing the stolen weapons charge. So if you're a judge, keep up with what's going on in your court. And while a judge cannot interfere in the charging process, you can ask questions because you have an obligation to make sure that what's going on in your court is fair. Before I go to your questions, I'm going to make just a couple of other comments. Remember that public trust and confidence in the legal system is grounded in perceptions of fairness and equality. And the judge, the lawyers who practice there, the court support staff, all have an obligation to promote fairness and impartiality. There are certain behaviors that we need to be mindful of to ensure that the public is not only receiving fairness, but they're also perceiving fairness. What are some of those conducts? Well, there are some of the ones that Dr. Wondrak talked about. We need to make sure that we're not communicating hostility and stereotyping to certain participants, litigants, witnesses in the courtroom. We need to make sure that we're not addressing one group by formal titles and addressing other groups by first names or some lesser title. We need to make sure that we don't automatically assume that the person of color or is the defendant, or that the woman is the court reporter or the court clerk. We should not make those assumptions, but we should, if we're unsure, we should ask. And you might, instead of asking, are you the court clerk, you might ask, are you counsel for which party or whatever. But anyway, make it in a way that empowers the person who may not necessarily be treated in the higher status at first. And we need to avoid exploiting racial stereotypes and biases when they are before us. So becoming aware is key, but also taking appropriate action is also key. So what are some of those things, those words, those actions that people might interpret as indicating bias? And what role do you have in reducing those? I want to say it again. Public trust and confidence in the legal system is grounded on perceptions of fairness and equality in our courts and in the offices that support them. And so we need to do what we can to make sure that people perceive they're treated with fairness. I want to go back to when I first became a judge. You heard Michelle tell you that I was a judge in a General Sessions Criminal Court back in 1982. I was the first African-American woman to become a judge in Tennessee's history. The clerk of court staffed my courtroom, support staff. And he was a friend of mine. He was a middle-aged white male, but he was a dear friend who was concerned about my success, my comfort, my ability to have everything I needed to do the job that I had been elected to do. And so he was also the person responsible for staffing my courtroom. So when I took the bench the afternoon of September 1, 1982, this is how my courtroom looked. I was seated there in my black robe, an African-American woman, seated in an elevated position. Right below me, I had 2 minute clerks, people who are keeping the record, an African-American man to my left, an African-American woman to my right. At a 45-degree angle was the prosecutor, an African-American male. And ringing the courtroom were my 4 security team, my 4-person security team, 1 African-American woman and 3 African-American men. The first person to come into the courtroom was a young white male. He walked in, he looked around the room ever so slowly. His eyes grew as wide as half-dollar bills as he saw no one in there who looked like him. He came to the bench with fear and trepidation and asked me for a continuance, and I granted that. 30 days later, he came back to court with an African-American defense attorney. Now, that may have been the person he was going to hire anyway, I don't know. But I suspect he was concerned about whether or not he could reasonably expect to get justice in a place where there's no one who looked like him. After that experience, I went back to the court clerk and I said, I appreciate your desire for my comfort and my success, but I think we need some diversity in the courtroom. Let's change out some of the court personnel and bring in some different court personnel. We changed out 2 of the African-American males and brought in 2 white males. And even though those people had nothing to do with the adjudicative function, I think it made a difference in the culture of the courtroom. Diversity is important, not just because it's the right thing to do, but it does impact and affect perceptions of fairness. I want to quickly, in the last 2 or 3 minutes, mention a couple of other things. We are responsible for how our court personnel conduct themselves and how they react to and treat other people. So we need to make sure that our court personnel understand the role of bias and the conduct that might exhibit bias. When we are writing our opinions as judges or as arbitrators, we need to be concerned about our tone. Are we being condescending? Are we treating the corporate entity with utmost respect and treating the individual with some lesser degree? We need to look at how we're also evaluating conduct. When people look us in the eye, are we threatened by that? Do we believe that they're being hostile or that they're being disrespectful? In some cultures, looking someone in the eye is a sign of respect, but in other cultures, it may be that averting one's eyes to a person of authority is the greatest show of respect. So learn about the culture of the groups that are coming before the court. Watch your communication. If you're on the bench and you're a judge, if you're interacting with one lawyer because you know that lawyer, they look like you and act like you, but there's another lawyer whom you don't know, but who is a person in that position and you're totally excluding them, are you sending signals that there's something special going on between you and the one lawyer that might impact the outcome of the case adversely to the lawyer who is in the out group? Do you speak more slowly to the person who's got a disability because you believe that people who are disabled unconsciously, you believe that perhaps they are not up to snuff, that they can't exhibit the same skill set that the more able lawyer can? What kind of images are displayed in your courtroom? Are they all people who are of your heritage and descent? If you're looking at, if you're a prosecutor, you only have pictures of mugshots in your office that remind you that certain people are more criminal than others. If you are the judge, how do you indicate I mean, if a person is nodding, a person with an accent is nodding when you're talking, are you interpreting that as them understanding fully what you're explaining? And do you not go back then and give a more fulsome explanation or test their ability to communicate with you about that topic? Examine your own habits and see if any of those indicate some type of unconscious or conscious bias. Do you refer to women as honey or sweetie or dear or Jane or Linda instead of counselor or avocado, if that's where you're practicing? And do you address majority counsel as Mr. and address lesser counsel as something else? In my community, I mentioned some of the things that led to these biases, but there was a time in this community when African-American lawyer practitioners could not get judges to address them as attorney. The judges would ask or Mr. The judges would address their white counterparts as Mr. Smith or Lawyer Jones or Attorney Edwards, and they would address the African-American lawyers as Ben or Joe or Otis or whomever, and they would not refer to the clients as Mr. or Miss, but they would refer to them in court using negative derogatory slurs. And during that time, in order to cope with to get some minimum modicum of respect, lawyers went to using initials so that if they weren't going to get addressed by courtesy titles, they would at least have to use initials. And so that was one way of coping. If you understand that biases affect outcomes, if you believe, for example, a stereotype that a certain group is more sexually aggressive, or it might affect your award of damages. If you believe that a person unconsciously, that a person is not worthy of something in your awards, that might affect the outcome of how you treat and how you evaluate their testimony, statements, and where you end up on the damage scale. These things affect us in myriad ways, so it's important to learn about unconscious bias. I would encourage you to take the implicit association test. I know that there's a debate about whether or not it is totally reliable, but the results are anonymous. And what it is an association. Whether you associate certain concepts, terms, beliefs with certain groups. So there are all kinds of tests. So just take it. And also try to develop a personal monitor, somebody that you trust who can let you know privately, confidentially, if they have witnessed what they believe conduct that is biased or words that are biased, and talk about that. And then be mindful, stay in the moment. Try to be aware of your speech or your attitude, whether you look at certain people or look away, whether or not you give an indication that you are engaged or whether you are dismissive, because those things can be a reflection of these embedded biases. So I want to stop there, and I'll turn it back to Michelle so we can facilitate questions.
Thank you, Judge Donald, for this very insightful talk. The first question, Mr. Wondrak, if we confirm to the group, do juries make sense? And does a tribunal consisting of several people lead to a fairer and more equitable decision?
Good question. Actually, yes, but you should be aware that the people have different, are diverse actually. Yeah? If they're all the same, from the same type and the same thinking, it could lead to the same decision. If you have different people then and with more perspectives, then I tend that there will be a discussion about different viewpoints and so on, and that makes it important and more could make it more objective.
And what is your view on that, Judge Donald?
Well, I'm a strong believer in the jury system, but I do believe that the groupthink concept is real. And once we send the jury to the jury room, we don't have any control over how they discuss this. So it's important to emphasize to them to discuss it and to emphasize that every juror's view has value and is valid. But it's also important what we do before we give a case to a jury. And let me tell you why I say that. I spent 15 years as a trial judge. I was I was presiding over a drug trial, and I allowed the lawyers to get into the voir dire, and sometimes having different perspectives, asking questions before we get the jury seated can be really important. In this particular instance, I asked questions and the prosecutor did, and then the defense attorney stepped to the well of the court and she asked the Venari the following question: how many of you know what a drug dealer looks like? Raise your hand. And they all raised their hand. Now, you and I know that none of us know what a drug dealer looks like. There is no profile of a drug dealer. But these people had it in their mind, and I'm sure they had it in their mind, a stereotype from TV, because seated over at the table was a young African-American man who looked like he'd walked right out of central casting for the role of drug dealer as we see it in popular press. So when we go into the jury room, I think it's more important for us judges to perhaps talk to people about groupthink and to let them know whoever they select as foreman needs to respect and give everybody a right to discuss the case and not just go in and make a vote, because it can have an impact. And we see that, I think, displayed with the number of cases that we're now finding through DNA and the Innocence Project where people have been wrongfully convicted. I think it does call into question. And I think the questioner for that question, because I think it's real, we need to do better and we need to do more.
And do you think that the problem with bias can be solved through artificial intelligence, or would people, would they accept a decision made by artificial intelligence?
Okay, I know that we rely on artificial intelligence for so many things, and it's getting to be even more sophisticated. But I would also caution people to be wary of artificial intelligence, because it's kind of that old garbage in, garbage out theory. Some person has to develop the algorithm, and we can actually bake in certain biases through these algorithms that all we're doing is shifting it from the person to the algorithm. I think we do want people to be involved in the decision making, but we want them to have to see things through a wider lens. I think artificial intelligence can do some things, but I would not want to see us move to a system where guilt or innocence and all of the nuanced factors that go in there that I think artificial intelligence probably would not be able to address. So I don't think that it is the cure-all. Dr. Wondrak, your thoughts?
Actually, I always get people or companies always ask me the same question. And there are a lot of studies and cases where we have seen that AI has also biases because they got in, or we have, or the algorithm was not correct. So I always suggest, recommend that they should use the AI, the algorithms, but they should use it to compare to their own decision. Yeah, and see what is the difference between when I would decide and what would be the system decide. And because this, there will be a reflection loop by comparing the two results, and then still make the personal decision at the moment. Yeah, because especially it goes about people decisions when hiring and so on. I wouldn't rely 100% on AI. I would rather use this information to compare to that what I would decide.
And there are questions by the participants. Very interesting, thank you. Judge Donald, have you ever had to deal with judges as colleagues who recently have issued unfair decisions given to their bias, and how did you deal with it?
Well, that is an interesting question. I have colleagues with whom I disagree on certain things, and there have been decisions that I believe are unfair. But part of this, I think, comes from laws that I think can be applied in ways where we were not really able to take into account all of the circumstances. I think one area where I've seen a lot of this is in the qualified immunity context in the US, where an officer commits a harm and the law says, well, the law was not fully developed and this is not something that a reasonable officer necessarily would have known or should have known. And so the officer gets a pass. In many of those instances, what I have done, first of all, I argue in conference. I strongly argue my position in conference. A couple of times, without mentioning the particular case, I have been able to prevail by swinging somebody to my view. And other times I've not prevailed. And sometimes I've written a very strong and stinging dissent because I think the law is wrong. And two of the cases I mentioned here, remember that in our jurisprudence, the court said that separate but equal was okay, and you had one dissenting judge. It took 50 years for them to come around, but eventually that dissenting view prevailed. And I think when my colleagues and I disagree, we have to respect each other's position. Sometimes I think it's influenced by bias. And remember I said that all of this comes from lived experiences. I want to go back to Dr. Wondrak again. This groupthink thing can be really serious. If you have everybody on a court who comes from the same background, who's had the same lived experiences, there's nobody to help you guard against your blind spots. And I think it's important to have clerks around us who have different lived experiences, because we reinforce that when everybody has had the same, we've gone to the same schools, we have the same lived experiences. But when we get those different experiences, and I try to always make sure that I have clerks who have different life experiences because they serve as a check on me. But I think it's important to speak up.
Thank you very much.
Sure.
And the next question is also for you, Judge Donald.
Okay.
Could you comment on how minimum sentencing guidelines interact with biases, even if they would seemingly look to make sentencing more predictable and even-handed? Thank you for a great presentation.
Sure, thank you. There's a huge bias in the sentencing guidelines. Courts have looked at across the country and compared sentences in different cases and come up with a standard. But within that standard, we have some flexibility. We can go low end or high end. But with minimum sentences, oftentimes those minimum sentences apply in areas where many of the people coming through there are in a category that they are disproportionately sentenced to these harsh sentences. In the case I gave you before, and one related to that, you recall that when the sentencing guidelines were formed and you had the mandatory minimums, people who were convicted of crack cocaine crimes were sentenced at a rate of 100 to 1. Their sentence was 100 times more harsh than a person sentenced from a cocaine conviction, even though crack cocaine was a derivative or a combination of whatever of cocaine. So facially, it appeared that the law was unfair, and it was unfair. It was based on these biases and the stereotypes associated with people that Congress deemed were more criminal. In the United States, whites and blacks use drugs at roughly the same rate, but the blacks generally are the ones who are in the system, convicted at higher rates, and are still getting harsher sentences. Another thing, guns. I had a case where a man who was paranoid, schizophrenic, and bipolar was on medication, and people are now living in the community. This man got off of his meds and was in the community drinking liquor and smoking crack, had been doing that for about 6 days, and he was not taking his medicine. But fortunately, on the 6th day, he realized that he needed to get help. So he called the police helpline and he said, "Help, I've been drinking liquor and smoking crack for 6 days. I am nearing a crisis. I'm afraid if I don't get to the hospital, I could hurt someone. Please come and help me." And they did. The police came. He had a little bag with things in there he'd gathered. They told him, "We're going to have to first check that bag to make sure there's nothing in there to hurt you, us, or the people at the hospital." Good police work. They dumped the bag on the hood of the squad car, and in the bag they found one .45 caliber bullet. They took him to the hospital. They took the bullet ultimately to the federal prosecutor. The federal prosecutor indicted under the mandatory sentencing guideline, mandatory sentencing provision rather. That man was looking at a minimum of 15 years in federal prison to a maximum of life for that crime, that conduct, when he asked for help. Now, did the law say that that was what the law is? Yes, it did. But that's ludicrous. Congress passed those laws to get at gun runners. Here there was no gun, there was just a bullet, but the thing also swept in ammunition. And I would venture to say that had the defendant not been poor and Black in Memphis, that case would never have been charged. So sometimes we see bias in it at the beginning. Sometimes we see bias in the conduct. But yes, to your question, there is bias all across the board, and Congress needs to go back and take a look at this. And that is why you have oftentimes people serving long sentences for minor crimes, like in prison for life for a mere shoplifting crime because of 3 strikes. You all have heard about those. So yes, we need to go back and look at that. We have not looked at the disproportionate use of resources that oftentimes flow from this biased conduct in communities.
Thank you very much. Unfortunately, I have to close this session now. I wish we could talk about it and continue this talk. We could fill a day, I'm sure, because it's so interesting. Thank you very much, Judge Bernice Donald. Thank you very much, Manfred Wondrak, for this insightful speeches. And thank you for answering the questions.
Thank you.